Now commencing our session. First, may I now invite Mr. Nish Shetty, Co-Chairman of the MCIA Council of Arbitration, to offer opening remarks.
One of the things we want to be known for is timeliness, so we will crack on. Good morning, ladies and gentlemen. It gives me great pleasure to open the substantive discussions at the second annual conference of the MCIA. The theme for our discussions today is the changing landscape of arbitration in India. I've been involved in arbitrations involving India or being related to India for some time now. And I've been observing from Singapore, where I'm based, the developments in the arbitration space in India. I think it's fair to say that the last few years have been a period of significant change. It started with the Balco decision in 2012, but the pace of change has really picked up in the last 2 years. And I just want to highlight some examples of that. And this has been touched upon by members of the judiciary this morning. And one of the big items of change is really the legislative changes that have taken place through the amendments. The amendments to the Arbitration Act came in December 2015, just when we were about to complete the first draft of the MCIA rules, or actually the final draft of our MCIA rules. The amendments came in, and then we had to make some further changes to those rules to take into account the changes. I think what we have in the end is a set of rules that takes into account the latest position on the ground in India. But from a change perspective, from a landscape perspective, those amendments to the Arbitration Act have been very, very significant. Again, those following the development of arbitration law in India, before that, would be aware that there was a consultation paper that was making its rounds for almost a decade, and there wasn't much clarity as to when any of the items within that consultation paper would be accepted. Then all of a sudden, in December 2015, almost out of the blue, the amendments came into force and represent a significant step towards promoting arbitrations and arbitration in India. Through those amendments, significant inroads have been made in terms of arbitration law, from the narrowing of the public policy exception, to the strict time requirements for completion of arbitrations, to the removal of the automatic stay, to the introduction of IBA guidelines as a schedule to those amendments, in relation to conflicts in particular. While I know that there are debates about whether the amendments are perfect, to me, that's not the question. The question really is, have the amendments been effective in taking arbitration to the next level? And I think the answer must be an emphatic yes. Yes, some fine-tuning needs to be done, and I know that in terms of that fine-tuning, consultations are underway at the moment. It already has had a significant impact on the way arbitrations are being conducted on the ground in India. So that's the first change in terms of the landscape. The second is promotion of institutional arbitration in India. You would have heard various speakers this morning talk about how institutional arbitration is the way to go, principally because the prevalent ad hoc arbitration method has frankly not worked out within the Indian context. Yes, we have ad hoc arbitrations outside of India as well, and perhaps they work in different ways depending on the jurisdiction, but certainly in the Indian context, they have not worked as well as they ought to have. So insofar as the setting up of the MCIA and the buzz that it's created both in India and internationally, that has been part of this change in the Indian landscape, has been an integral part of that change in the Indian landscape towards institutional arbitration. As many in the room will know, Mumbai, which is in the state of Maharashtra, is part of, or the beneficiary of, a policy that's been introduced by the government of Maharashtra that encourages institutional arbitration. As part of that policy, government-linked entities or public sector undertakings, as they're called in India, are required now, are mandated to use institutional arbitration in the contracts that they enter into where arbitration is the preferred mode of dispute resolution. And I think that is another welcome, far-sighted initiative on the part of the Maharashtra government. It remains to be seen whether other parts of the country will follow suit and similarly encourage institutional arbitration. Even if they don't, I think it's telling that the Commerce Minister himself is delivering the message that institutional arbitration in India is a requirement. It's telling that the Chief Justice, you heard him this morning, delivered a similar message. Justice Sikri, a very senior member of the Supreme Court, is delivering that message as well. So I think it does bode well for India from a landscape perspective that institutional arbitration is being embraced. In terms of developments and the change of the landscape in India, the other development I wanted to highlight was things like conferences such as the one that we're in right now. Quite apart from, MCIA, SIAC, ICC, and the other institutions organizing conferences such as this, last year in October, the Niti Aayog, again, there was a reference to the Niti Aayog earlier, organized a conference focused on arbitration, and it was held in Delhi, very well attended by both international and local practitioners. But really the message there is that the Niti Aayog itself organized it. And for those who are not from India and who don't understand the significance of that, it's effectively the replacement body of the Planning Commission that has such a huge role in the development of Indian policy. So the Niti Aayog itself is focusing on arbitration. The fact that the head of the Niti Aayog, Amitabh Kant, who was referred to earlier in the speech, has also suggested that enforcement of arbitral awards is the next step towards ensuring that India jumps another perhaps 30 or more steps within the ease of doing business ranking, is again a very positive indicator from a landscape perspective. So something else to look forward to perhaps. Straight after that Niti Aayog conference, a very high-level committee was set up, headed by the Honorable Justice Sri Krishna, to look into the state of arbitration on the ground here in India. A very detailed report has been published. Again, it's in the public domain. You can get it. It's online, and you can read it. There are debates ensuing at the moment as to whether that report the recommendations of that report should be followed, will be followed, will not be followed, etc. Again, to me, it misses the point. That sort of a debate misses the point. The fact that a report of that nature was commissioned in the first place is indicative of where arbitration has come within the Indian context. And I think that's what we need to celebrate. Arbitration is important in India, and it's gaining importance. In terms of arbitration practitioners and the interest in terms of arbitration among those practitioners in India, that's the other aspect that one needs to bear in mind. And that interest is reflected both from those who are on the ground here in India and from those who are operating in the arbitration sphere outside of India, but with an interest in India. Starting with those in India. For the longest time, arbitration in India has been conducted as an extracurricular activity. Once you're done with your litigation matter, between 4 and 6 or 5 and 7, together with tea and biscuits, you conduct your arbitrations. That's been the norm. The result is obvious. The result has been arbitrations that last as long, if not longer, than the court process. And as we all know, the court process does take a long time in India. With the amendments to the Act and the timelines that have been imposed, there's a greater awareness of how arbitration should be conducted, right? In a timely manner, in a cost-effective manner, and that is changing. Not everywhere, but it certainly is changing. There is also greater exposure to the way international arbitrations are conducted because Indian parties and Indian counsel are going outside of India and participating in international arbitrations, whether in London, whether in Singapore or elsewhere, but they're certainly participating. The other trend, insofar as that's concerned, is the younger lawyers, those in universities, in the Indian universities, are participating in international moot court competitions and the like, and gaining exposure that way as to how things are typically done in the arbitration world. And all of this bodes very, very well. In the same vein, MCIA has been conducting training programs for the younger arbitration practitioners throughout the year, and which are always oversubscribed. Other organizations such as the IBA, ICA are organizing sort of capacity building activities on the ground here in India. So certainly there is both interest and the ability to now learn how international arbitration and arbitration generally ought to be done. Just in terms of arbitration conferences, which are a perennial favorite among arbitration practitioners both here and elsewhere, I would say 3 years ago, as recently as 3 years ago, getting 50 people into a room to attend a conference on arbitration was difficult. Right? Today, we have a sellout conference yet again, over 230 participants. Just last month in October, in the middle of October, just before Diwali, there were a series of arbitration events in Delhi spanning almost a week. Right? All the key institutions were there organizing these events, and almost every single one of them was fully attended. Right? What's the message there? People are willing to take time away from their busy schedules and attend these conferences, participate in the discussions and dialogue that's going on in the arbitration space, and that can only bode well. In terms of arbitration practitioners within India, I've always said that the time is now for there to be an arbitration bar, such that it's no longer an extracurricular activity, but practitioners on the ground in India treat this as their primary role, meaning they are arbitration practitioners full-time. I know a number of the top firms now have individuals that do that, but I would welcome that change in the landscape to go beyond just the top firms into the broader arbitration market in India. I've dealt with those within India. Let's talk a little bit about those from outside India, including myself. Right? If you look at the program today, just as one example of who is interested from outside in terms of arbitration in India, you will see that there's some very senior names from all across the globe who've taken time off their busy schedules to come here and participate in this dialogue about arbitration in India. Similarly, that happened in October in Delhi as well. And I think all of this indicates a significant change in the arbitration landscape in India. I don't see this trend reversing. In fact, I see this trend becoming far more significant and far more apparent in the coming years. So in conclusion, I'd say this: the landscape in India for arbitrations is changing rapidly. There are issues still, but those issues are being resolved, I think. For those practitioners in India, I say embrace this change, help shape it. And from those from outside India, I say take notice, as the endpoint of this change may result in this being among the most important arbitration destinations in the world in the coming decade. I'll just throw one metric out there to justify that point. I'm told that today there are 50,000 ad hoc arbitrations being conducted in India as we speak, right? Ongoing arbitrations. If you aggregate all of the cases that one has in SIAC, ICC, LCIA, etc., it won't even come to 1% of that number. That's what one has to play for. If ad hoc arbitration moves to institutional arbitration and international arbitration practices come to the ground here, then there is going to be a significant rise in arbitrations on the ground here, conducted in accordance with international best practices. The MCIA will play its part insofar as that is concerned, but there will be other institutions as well in due course, perhaps. But what's more important is that the arbitration landscape will continue to evolve even beyond what has happened in the past few years. We've got a full schedule ahead of us, and I look forward to hearing all of the panelists and moderators insofar as that schedule is concerned. It just remains for me to thank all of you for being here, and I hope you have fruitful deliberations right throughout the day. Thank you very much.
With that, can I please invite our panelists for the first session on negotiating contracts and the importance of arbitration clauses on the stage. I will welcome Mr. Cyril Shroff, Managing Partner at Cyril Amarchand Mangaldas, Mr. Janak Dwarkadas, Senior Advocate at the Bombay High Court, Mr. Nakul Dewan, Counsel and Arbitrator at 20 Essex Street, Mr. Richard Menard, Senior Foreign Attorney at Chang, Ms. Rohini Roy, Head of Legal Operations at Bharat Heavy Electricals Limited, and Mr. Robert Hunter, Senior Counsel at Osborne Clark.
Welcome, everyone. It's my privilege with my colleague Nakul Dewan on my left to moderate this panel. It's indeed a very distinguished panel, and so we cover really not only so many legal systems, but so many points of view. I think it's going to be a very interesting debate ahead. I think I'm not here merely because I'm a great fan of institutional arbitration. I think it's a reminder to corporate lawyers who draft these contracts that you should really be mindful of some of the nuances that we are going to discuss, because this, as we will sort of presently see, is the typical 5 a.m. clause that gets negotiated. So I think that's how I would justify my existence over here. Nakul, of course, is a great practitioner in this, and we are looking forward to run this together. I'm going to introduce two of my panelists on my right, and then Nakul will do the rest. So, Janak bhai, it's a great pleasure to introduce you. I think you are beyond introductions, but as one of the senior most and most respected members of the bar, thank you for being here. I'm not going to go into the formal CV which is in the program. Then my friend on the extreme right, Richard Menard from Chang, who's had a diverse sort of career in arbitration and litigation, having practiced in the US and now based as a foreign attorney in Korea, and clearly a major player in this space. So thank you for being here. Nakul?
No, and adding to our diversity, we also have Robert Hunter, who's lived and worked in London, New York, and Frankfurt. I mean, all these will give you live experiences about different countries, different jurisdictions. But I think it will probably also tell you that a lot of the problems that we face are actually very similar, as Cyril pointed out, the 5 a.m. clause. We also have Rohini Roy. Now, Rohini it plays a very critical role in our discussion, and the reason why she plays a critical role in our discussion is because A, she's part of one of the largest PSUs in India, that is BHEL. 2, they invest outside of India, and they've got a presence in 83 different countries. So it's no longer a case of a PSU looking at an arbitration clause for disputes which have arisen in projects in India, because she's looking outward. And I think what you will get from her will be extremely critical. Now, before Cyril kicks off this session with his first question, let me just tell you what we did have. We had a discussion amongst the panelists a week ago. And what we realized, and this was based on the last MCIA conference, was that the audience here is a very sophisticated, very knowledgeable audience. So the bar that has been set for our speakers is very high. They're not here to just simply tell you, well, don't have a bad clause, have a clear clause. They're here to tell you lots and lots more. So with that, let me ask Cyril to kick off the first question.
Thanks for that, Nakul. So my first question really directed at Janak bhai and Richard Menard on the sort of a more broader question on the setting between the arbitration movement on the one hand and the sort of rise of commercial courts as a concept and really how these two themes are playing out. There are murmurs in the broader sort of arbitration and disputes community that we can't take the trajectory of the rise of arbitration for granted. It has certain flaws and drawbacks, and there is not a complete disenchantment with the normal sort of court system. So there is some competition playing out over there. And the commercial court theme, both in India and overseas, have sort of different dimensions as well. So it's the first question really on the commercial courts is, Janak Bhai and Ricard, given that commercial courts specialize in having judges who are commercially trained, do you still consider it important for parties to have an arbitration clause in their contract? What's the future of arbitration in this context?
Thank you, Cyril. Morning to everybody, or maybe it's afternoon by now. The question has been posed is, do you believe that commercial courts, in that sense, having been set up in India, would render to some extent the need for commercial arbitrations? I would begin by saying that in the normal course, it is not everybody who can afford the luxury of a commercial arbitration. And we all know why. You have to pay the judges, first of all, besides the fact that you have to pay your lawyers. And if it is, of course, seated outside of India, then it depends where the seat is. You would have to incur those expenses too. So having a commercial court within the country, of course, provides a viable alternative to the litigating public, provided, of course, it's an effective tool or an effective dispute resolution mechanism. Now, India has taken that step with the idea of improving the ease of doing business. And with that, we have a commercial court with experienced judges. At the district level, it's called the commercial court. At the high court level, it's called the commercial division, followed by a commercial appellate division. And they're supposed to be manned by expert judges. And of course, there is streamlining of procedure. There are strict timelines to be observed. There's a case management system, etc., etc. There's a provision for summary judgment, as you know, and whatnot. And there are time limits within which the case has to be disposed of, both at the lower court level as well as the appellate court. Having said that, and having looked at the advantages, the real question is, at the practical level or on the field itself, is this working out? Now, let me tell you, the drawbacks today we find as practicing lawyers is that it is not yet, we do not have any publicized statistics to show whether the disposal rate or the disposal by the commercial court has in fact been as effective, or it is showing such results. But even then, in the absence of statistical data, let me tell you as a practicing lawyer, there are some inherent difficulties in implementing the provisions, principally because we have a system in India where the judges of the High Court are assigned work by the Chief Justice of the court. And there is a practice, as you all know, in the High Courts, that the Chief Justice rotates the judges from time to time to give them the benefit of diverse experience of diverse laws. Now, that doesn't help because it is not as if the commercial court judge remains in the commercial court or the commercial division at all times. Equally, at the appellate stage also, it is not so. So you have a rotation of judges with the result that there is less continuity. The other problem you have is, of course, that judges themselves who may be heading the commercial division or the appellate division are required to discharge various other judicial functions and look after several other matters under various other jurisdictions. So that also adds to the problem. And the third thing is that you have transferred the pending cases, which are defined as commercial cases, disputes, to the commercial courts and the commercial divisions, with the result that there is a backlog of commercial disputes, there is a backlog of other disputes which are already pending in the High Court, and you do not have, the judges do not have the facility or the ability to be able to effectively deal with the new role that they have now been assigned. So, and of course, if it goes to the appellate court, then the appeal court is equally flooded, backlog and delays and whatnot. So I would say that this law is in its infancy. If it stabilizes and systems are put into place and really put into practice, we may see a shift towards commercial courts as a viable alternative to commercial resolution of commercial disputes. And that's how I would like to put it as far as India is concerned. My friend, of course, would tell us more about the international experience.
Thank you very much. There are three critical factors at the highest level in the choice from an international point of view. The most important usually is the question of enforcement. One reason, the main reason for the growth of international commercial arbitration as a form of dispute resolution in international trade is the New York Convention, to which there are now 157 state parties. So that alone would justify a choice of arbitration over litigation where there's any doubt about the enforceability of a commercial court judgment in the place you are likely to want to enforce. That may change over time because there is a Hague Convention on choice of court agreements, which will be for neutral forum courts what the New York Convention is to arbitration. At the moment, there are only 3 parties. However, the United States and China have signed, and that may present a greater challenge in due course. And Singapore is already offering a commercial court for that purpose. The second critical factor is the question of finality. In arbitration, typically, there is only one instance. You may like that, you may not like it, but it is a difference to litigation. And that instance is typically subject only to review of due process by the Court of Supervision and any courts of recognition. Thirdly, and most difficult to summarize shortly, is the question of the respective roles and functions of courts and arbitrators. One aspect of this has been touched on by my colleague. The court's primary function is as one of the 3 branches of government to administer justice, and that role goes beyond the determination of individual disputes to the rule of law in society as a whole. And as we've heard, they also have to organize, courts have to organize their procedures within the constraints of the public allocation of funds and resources and weighing the interests of society as a whole. An arbitrator, on the other hand, is appointed by the consent of the parties to decide the dispute for the purpose, for that dispute alone. I'm leaving aside here the more complex questions of treaty arbitration. This creates a number of fundamental differences, and the manifestations of these are hugely complex and far-reaching. A couple of examples: it frees the procedure from any requirements of national proceedings. This allows a dramatic potential to increase the efficiency and the cultural neutrality of proceedings with regard to every aspect: scheduling, place of hearing, language, degree of formality, informality, innovation, confidentiality, communication, cybersecurity, even whether there should be an oral procedure at all. This has many advantages for international parties. Secondly, it leads to a different relationship of the tribunal to the parties. As Mr. Justice Sikri said this morning, it gives the parties a great deal more control over their procedure, and to the extent they can't agree it, a tribunal should know that it owes its existence to the will of the parties. So the parties are, in my view, entitled to expect a service mentality in terms of the efficiency and convenience of the procedure. And thirdly, most controversially, it possibly introduces a more subjective element into decision-making, deriving from the fact that the arbitration tribunal is an ad hoc tribunal. One legal scientist has written that the judiciary, through routinization, habitualization, has an emotional disengagement, which he described as the capacity of anesthetizing the heart, in contrast to the personalized justice of arbitration. I shall leave you to ponder the accuracy of that one. Thank you very much.
Would anyone like to add anything to this before we move to the next question? Rohini, Ricard?
I mean, and now, I mean, we've got a general broad idea. Now I want to go straight into a more specific question, which is closer to the topic that you've got, which is negotiating contracts and the arbitration clause. And one of the problems that we have often faced is that when you've got large, high-value contracts, you know, let's look at 100, 200, $300 million contracts, you end up having a clause which provides for 3 arbitrators, provides for an institution, and also provides for a neutral venue. Now, all that is very expensive. But the reality is that out of that $500 million contract, you end up with a dispute which may just be $100,000. Now, my question really is arrowed first to Rohini and then even to Richard. And my question is, in a situation such as this, when you know that you might have a small value dispute arising out of a large value contract, what do you do when you're negotiating? Do you think about it? Is it relevant?
So I think that there are 2 ways to really look at this question. One being that how important is a claim value when it comes to large-scale procurements? Unfortunately, there seems to be a big divide between how the private sector handles this and how a public sector or the government sector handles this. Primarily, this difference comes because of the way on which and the scale on which the procurement is done, where the claim value itself, coming from the public sector's viewpoint, could be a very minuscule consideration. It is agreed in general, theoretically at least, and we'd all like to probably agree on this, that a sole arbitrator is much more cost-effective, perhaps reduces some of the perils that a 3-party tribunal may have. But there is a reason why, despite all of these advantages, people keep using and reusing the 3-party format. And these go beyond the claim considerations. I think part of the problem lies in a fundamental question of faith, especially for the public sector or the government sector. I think faith plays a very important role. We are all in a sanctuary where arbitration itself has lost quite a great deal of faith, at least speaking from the Indian perspective. And even when we do our international disputes, we are finding it difficult to trust the process in terms of time, cost, the kind of decisions, the kind of technical expertise. So faith plays an important consideration, because of which we have the emergence of the 3-party format. The other consideration which plays an important role and why the sole arbitrator is not selected is probably the issue of expertise, because we find it difficult to find a pool of arbitrators who seem to have both the legal as well as the technical expertise together. And when it comes from the construction industry, like mine, for example, the technique plays an equally important role, if not more. It becomes difficult then to select a normal 3-party, a normal sole arbitrator format. And the 3-party, we believe at least one of them could be disposed technically. Not that this comes without its problems, but the other issue is also the social and cultural ethos, because there is, whether we like it or not, a natural tendency to go towards the social and cultural sentiments of the parties. So if there are arbitrators who are region-specific, it is very natural for them to tend and bend towards or understand the arguments, the cultural arguments and the political and social arguments of a party belonging to that cadre. So these are some of the considerations. Plus, I think the difficulty that we face, especially for public procurements, is the fact that most of these, when you're a service-based industry, which is providing business essentially to international clients, It's a very client-dominated contract. Most of these are tenders, and they come with their own no-deviation formats of clauses. Typically, the arbitration agreement, in my experience, has not been something which they're very willing to negotiate on. It's true that it's mostly all institutional, and we expect a very standard procedural framework of rules, but it does make it difficult to have party autonomy in negotiating such clauses.
Answering the same question from the private sector perspective, my first observation or thought, and I'd welcome my colleagues' thoughts about this as well, is that in a $100 or $200 or $300 million transaction, I think it generally can be assumed that it's unlikely that a very small value, like in the hundreds of thousands or low millions, dispute is going to mature into an arbitration, an open dispute. I mean, of course, it does happen, but the benefits of a three-member tribunal that Rohini has just identified are important, and they come at a cost. Now, it seems to me also that in broad terms, that the marginal costs associated with a three-member tribunal represent a modest, not insignificant, but a modest part of the overall cost of an arbitration. If that possible marginal cost, handicapping the likelihood of a relatively low value dispute maturing at some point in the future, is enough to give concern at the time of negotiation, then it seems to me that the only obvious solution to that comes to my mind is to leave the number of arbitrators unspecified in the contract, and assuming that it's that the arbitration clause provides for administration by an institution to allow for the institution to make that determination in the usual course. I mean, another alternative, which I would not ordinarily recommend, would be to build in some kind of decision matrix into the arbitration clause, such as a threshold, claim value, that sort of thing that gives rise, that invites all sorts of mischief, I think, as we can all understand. That would be my general approach, and my general advice in relation to negotiation of arbitration agreements is to provide for a three-member tribunal rather than to leave it unspecified, and certainly almost never to recommend a sole arbitrator to be specified in the contract for essentially the reasons that Rohini well articulated.
Hello. If I could add to this, one solution probably could be Section 7 of the Arbitration Act, India, which says that in this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes. So one way out, as I see it, maybe the practical way out could be that certain disputes, which may be below a particular monetary threshold, may go before a single arbitrator, whereas disputes over a certain amount may go to a three-member tribunal.
And Janak, we actually have used this in some contracts. We actually have a two-tier clause. If I may move to the next question as we kind of dig deeper a bit. In relation to the actual drafting of the arbitration clause, and that involves the draftsman and the negotiating team actually making choices. Choices on a number of things, on the institution, ad hoc versus institutional, and the institution itself, choice of the number of arbitrators, timeliness for completion, costs, choice of seat, distinction between seat and venue, fixing of fees, measures, etc. So there's a whole lot of detail around determination of the clause, and the impact of these choices really manifest themselves in actually outcomes, good or bad, later. So question to Robert and thereafter to Rohini is, when drafting an arbitration clause, What factors should be kept in mind to ensure that there is maximum efficiency and minimum inefficiency arising out of poor choices? What have we learned from experience, and what should the draftsman be careful of?
Thank you. Our moderators have said we should not insult your intelligence by speaking of clarity or clarity alone, but nonetheless it is the single most important point. An unclear clause is inefficient. Beyond that, my second point is the choice of ad hoc or institutional. In some cases, ad hoc can be efficient, but in my view it requires sophisticated parties, a common will to achieve efficiency, and an ability to choose an efficient tribunal. Those are very hard and dangerous things to take for granted. The benefits of an institution can be very great, but there are many species of institution. So I shall concentrate on what I perceive as the benefits of the MCIA, or some of them, from a review of the rules, but I have not yet used those rules myself. In my view, it offers a high degree of institutional administration, and with it, much increased chances of efficiency. I'll highlight a handful of points. The first is quality assurance. That takes the form, first and foremost, as a veto over arbitrator appointments, and therefore the ability to exclude unsuitable ones, based upon both objective criteria and upon experience. It also includes the power to deal with challenges, takes that away from fellow members of the tribunal, and ultimately will never completely away from the courts, but at least an interim and probably final stage. And perhaps most importantly, the ability to remove non-performing arbitrators. Non-performance might be willful, it might be accidental, fateful. I have one example at the moment where we consider our chairman is physically unfit. It's a very difficult situation to deal with if a tribunal, if an institution doesn't have the power to step in. A second strong factor in favor of institutional efficiency is the ability to police the timetable, and that can be sanctioned by the first point. Thirdly, it reduces the need to involve the courts in problematic situations. That can also dramatically increase speed and possibly predictability. It offers, fourthly, a number of efficient procedures which you may or may not need, but if you do need them, they could be significant, such as consolidation in appropriate circumstances. And fifthly, it offers some degree, the MCIA does and the ICC do, not all arbitration institutions do by any means. It offers efficiency in some degree of quality control of the award. So at least a review by the institution may avoid obvious formal deficiencies that could be profoundly inefficient later, resulting at worst in the nullity of the award itself. The third point, which I'll pick up my colleague's final point, is that efficiency can be achieved by an intelligent choice of procedures. I'll take one isolated example, there are many. The MCIA rules offer the ability of the institution to apply expedited procedures upon the application of one party. That comes into play at a threshold of 10 crore, so disputes underneath that will be eligible for this application and decision. The ICC offers a similar procedure, but it's automatic for disputes of $2 million or under. What that offers, in fact, is a more profound duality of proceedings, of choice of proceedings, than just a sole or 3 arbitrators. It offers a deadline of 6 months for final decision. It imposes a choice of a sole arbitrator against any other provision in the clause. It enables the curtailment of all procedures. It even allows the decision to have a documents-only process in the discretion of the tribunal. So effectively, it is a different species of arbitration within a single choice of jurisdiction. And as a party, you can use this imaginatively. I have discussed this with German enterprises of a large scale who would not typically arbitrate or litigate disputes under thresholds of, say, $5 or $10 million or euros. They are actively considering and may even have chosen to apply the expedited rules in their agreement to disputes under that amount. But I'd be very interested to hear my colleague Rohini Roy's views on that.
I'm not going to add much particularly to this question. I think Robert has covered quite a bit already. But I do believe that increasingly we're at a day and age where the common interpretation of having a very detailed arbitral clause is put to test and question, because when I draft and negotiate contracts now, I'm not so sure if it is of any particular advantage to have a very detailed arbitration clause, although theoretically, again, we are aware of the various benefits and advantages that a detailed clause may have. But this has seemed to play havoc in the industry, because I think too much detail as well as too little detail both can be very, very hazardous. And in our experience, we've not dealt very comfortably with any of these either way. So while the seat being specific and the procedural law being specific, the amount of evidence being specific, the quantum of dispute being specific, and also the issues which need to be framed in the disputes being specific is of particular advantage, we have still managed to get ourselves stuck for years on these issues despite their clarity, and sometimes that clarity itself can be ambiguous. So I think when we talk about clarity in drafting, it's not a very particularly easily achievable target. And since now we have an industry where there is a lot of interpretation on even the most clear of clauses, we have continued to find ourselves getting stuck on these clauses, even if they're very, very detailed. So I'm not going to take more time on that question. We'll move on to the next if anyone has to add.
Thank you, Rohini, and I think the message is loud and clear. I mean, we are looking at clarity. Now, we've gone through this 5 a.m. business about arbitration clauses coming in at 5 a.m. And again, with absolutely no reflection on corporate lawyers. I mean, we've got one of India's senior most corporate lawyers sitting right next to me, so I have to be very careful when I get into this. You have horribly drafted arbitration clauses. Now, I'm actually going to arrow 2 people for something very specific, and I want to go into war stories to make you realize the magnitude of the problem. A typical defense which a lot of Indian parties take when they're arbitrating outside of India is to come with this legal theory where they say seat is different from venue, is different from place. So if you say venue Singapore, well, it means seat India. And you go and debate about this before the arbitrator, you debate about this before the court where the arbitration is being held, you go and debate about this before an Indian court. How do you do all of this? I mean, it is absolutely unbelievable. Richard's had some experience with that in the context of a foreign arbitration, and I'd like Richard to share with you his experience. But more importantly, and after Richard, so that the discussion flows smoothly, Janak, who we all know is one of Bombay's and India's senior most litigating lawyers, I'm sure has in the past had the experience of effectively arguing these clauses before courts and, with respect, derailing some arbitrations in that process. So again, I mean, Janak's experience in this will be absolutely valuable for us to understand the magnitude of the problem. Richard.
Yes, the matter that Nakul is referring to, the peculiar arbitration clause arose in sort of a peculiar way. It wasn't really the 5 a.m. issue. We've all had enough experience with very badly drafted arbitration clauses. This one came about because the arbitration clause in the original draft contract was a fairly standard domestic Indian arbitration agreement providing for that the dispute would be governed by the Indian Arbitration Act and all the rest that I'm sure most or all in this room are familiar with. And then in the course of negotiation, the non-Korean party, which was a Korean party, proposed, and this was accepted, an amendment that the venue of arbitration shall be Singapore. And there was also an amendment providing that it shall be governed by international law, whatever that means. But the Singapore bit came in that way, that the word used was venue. And I think it was clear that that the business people who inserted this language, I hope without the benefit of outside counsel, meant place in the juridical sense. The arbitration will be outside of India. It's going to be in Singapore. That'll be the place, the seat of arbitration. But the word used was venue, and nobody, in all likelihood, gave it very much thought until the dispute had broken out and was in arbitration. In that event, the notion that venue really meant seat was ultimately accepted, and the arbitration proceeded in Singapore, but not without a relatively long and uncomfortable prelude. So the moral of that story, I suppose, is just avoid the word venue, period.
Rather than talk about my own successes, which I don't propose to do, let me just, I know we are for a very educated audience, but I was intrigued when I saw the expression pathological clause used in the question. Well, I find that the author of that clause appears to be a gentleman called Frederick Eisman, who said that a non-pathological clause is one which must contain 4 elements. And the 4 elements are that there must be a mandatory consequence of the arbitration agreement. Example contrary to that would be where you say the dispute may be submitted. The second is that there should be an exclusion of intervention by state courts in the settlement of disputes. Again, where the clause would say, the clause itself might provide that courts in Bombay or courts in India will have jurisdiction along with the arbitration clause. The third is to confer a power upon the arbitrators to decide the dispute. And the fourth is the procedure for rendering the award must be capable of ultimate judicial enforcement. So these are the 4 requirements. Now, anything that does not comply with these 4 is regarded as pathological or a diseased clause. Now, I would like to give you an example of what happens when you have a pathological clause, because the consequences can be rather disastrous. Let me start, I know I'm going back in history, but let me start by telling you the error that was committed in the Bhatia International case, and this will illustrate what I'm going to say next. In Bhatia International, there were 2 errors which were committed by the Supreme Court. One was to define the court in such a manner as it had nexus with the cause of action and where it arose. The result of that was that it became a very narrow definition. In other words, it eliminated having a seat of arbitration in a neutral place. That was one consequence. The second was that it destroyed the principle of exclusivity. What is the principle of exclusivity? The principle of exclusivity is that a curial court or the arbitration, the court which has supervisory jurisdiction over the arbitration proceedings, would not be the court where the seat is located, but could also be an Indian court, because Part 1 would not have been excluded expressly by the parties. Now, this was to some extent attempted to be cured in the Balco case. But the Balco case said only after 6th of September 2012, agreements which are entered into will not be hit by what was described in the Bhatia doctrine. In the Bhatia doctrine. So that did not help. And that is why in 2015, the act had to be amended. And now we have a situation where the 2015 act recognizes that the seat can be in a neutral place. Now, with that change having been made, what is the need for the seat. Why is it so important? Because seat is, in my view, equal to jurisdiction. It is not a question of, because there are three laws which can apply, as you all know, to an arbitration agreement: the law governing the contract, the law governing the arbitration procedure, and the law governing the arbitration agreement. Now, parties do not identify, particularly where they do not identify the seat. The difficulty that arises is the law governing the supervisory jurisdiction would then become a question mark. And that is exactly what fell for consideration in two leading cases before the Supreme Court. One was the case of Amarchand. I did have something to do with it in the lower court. Ultimately, it was decided by the Supreme Court. Justice Nijjar has authored the judgment, where these principles which I have enunciated have been clearly laid down now, that the curial law, or the court which will apply the curial law, should be exclusive. It can't be, you can't have two different courts applying. Otherwise, it will create a problem. Like it was created after Bhatia. What happened was, in Venture Global, the Supreme Court was compelled to extend that principle to say that an award rendered outside India, which would otherwise be an international commercial award, would be enforceable, would be challengeable even in an Indian court. So to avoid this duality, supervisory jurisdiction must be exclusive, and that is why in Amarchand, there were two problems. One was that the language used was venue is London. The second was that there was no machinery to select the third arbitrator. So the Supreme Court had to decide whether it had jurisdiction to exercise any powers as the curial court. And the Supreme Court said venue in that particular case meant venue and not the seat. And it came to the conclusion that since all the three laws which were to govern the arbitration were Indian, they said the curial law which would apply to the arbitration proceedings would be Indian, and therefore they had the right or the jurisdiction to appoint the third arbitrator, which was left vague in the contract. The second judgment is actually a judgment of Justice Gogoi, sitting and exercising powers as a designate of the Chief Justice under 11 subclause 6 of the Act, where he had to decide what is the meaning of the word Singapore Chamber of Commerce, which was introduced into the arbitration clause. The parties there were Precall, which is an Indian entity, and Johnson & Johnson. Johnson & Johnson went to the Singapore International Arbitral Council and got an arbitrator appointed. Precall, on the other hand, the Indian entity, went to the Supreme Court and said, there is no such thing as a Singapore Chamber of Commerce. They had no business to go to the SIAC, and you have the power to therefore appoint an arbitrator and not the SIAC. The Supreme Court resolved it by saying there is a manifest intention to go to arbitration. We will not allow it to fall. There's no such entity like Singapore Chamber of Commerce. SIAC would therefore, by default, be rightly the entity. And since the seat is Singapore, we will allow Singapore law to be the curial law and decline to interfere with the appointment that was made by the SIAC. So that is the relevance of seat, and that is why these 5 AM clauses sometimes cause a lot of problem, which may be, as has been described, laughter to lawyers, but brings tears to legal philosophers. Thank you.
I know I'm getting, oh, stop. Yeah. So let's take a few audience questions, and then if time permits, I have a couple of other questions for the panel. Can any?
I am Pritesh Burat. We have gone through one agreement where there was a clause for an arbitration. Initially, the matter will be referred to an architect, but there was no name specification of an architect, and the point was how the things will move forward in that. Who will have the jurisdiction to decide who is the architect for that?
I mean, if parties don't agree on the name of the architect, then go to the arbitrator and get the arbitrator to make that decision.
I think your question was, if we've understood correctly, that the arbitration was to be conducted by an architect. Is that your question?
No, before going to an arbitrator, the parties will first go to an architect. If the parties don't agree with the architect, then they will go for arbitration.
So, yeah, so the parties would have to select an architect by themselves, and I don't know whether Section 11 would apply to such a situation, because the jurisdiction of the court, the arbitration court, does not extend to any stage prior to the arbitration in that sense commencing. So probably it might fail and it would go straight to arbitration. Can't be a mediation either.
I think this is probably in relation to one of those expert determination clauses. And typically, these multi-tiered agreements, I agree with you, they do create a lot of confusion, because at this stage, I don't think it's possible for us to really approach the courts at all. We would have to go through the expert determination process, and only if it fails, you'd be allowed to continue with the arbitral process.
But I think in his example, it's not even an expert determination. It's quite ambiguous as to what it really is. Anyway. The question at the back there.
Yeah. Sorry. I just have one question, which is actually a live and a funny case. Now with Section 9, being no more valid after the arbitral tribunal is constituted, and probably someone needs to look at this, because Section 17's got teeth, and Section 17's got gives the right to the arbitral tribunal to pass an interlocutory injunction or some relief. Now the question is, unlike a court, which is an institution by itself, an arbitral tribunal is people. Now what happens when the arbitrator or the arbitrator is not there, is not available? Let's say he's out of the country or ailing or something, and then there is a requirement, urgent requirement for interim injunctive relief. And Section 9 now being out, isn't that something the Act probably should have been slightly more circumspect on that? Because they've completely excluded Section 9 after the tribunal comes into place. Maybe to Janak bhai, yeah.
I don't think you're right in your assumption that Section 9 has been excluded, because it is only in such cases where the arbitral tribunal would be more competent to decide. Then in that case alone, the Section 9 court would not intervene. But I think what you're trying to say is, once the arbitral tribunal is constituted, it is provided that the applications will be made under Section 17. But the unavailability of an arbitral tribunal immediately restores the jurisdiction of the court, because it can't be that a party that requires urgent relief is left without a remedy.
Thank you.
Last year we had a judgment in the year 2016 on Centro Trade. That judgment spoke about multi-tiered arbitration clauses, and the Supreme Court finally said that this is a result of party autonomy. Now, given the situation in India, where the disputes between the parties had arisen sometime in 2001 or 2004, and the verdict of the Supreme Court comes in 2016, that's when, after this, there'll be another round of arbitration between the parties. Would you say that multi-tiered arbitration clauses are something that should be welcomed in India, or that's a practice which should be somewhat curtailed, or better arbitration clauses to be drafted in that terms?
Rohini?
I think the multi-tiered system is, it does have its advantages, in the sense that it provides an alternative from arbitration itself. But again, the question is essentially of perspective, because at the moment I'm thinking that the multi-tiered is not a solution, because it does not signify an end. Now, when you're a business house, you would want to concentrate on your core industry and not want to devote so much time to the process of continuously arbitrating and exposing yourself to multiple forums. And what the multi-tiered clause effectively does, especially when you're dealing with a large-scale industry, is nobody is happy with the process. So it may be binding. The problem is it's not final. And eventually, you're going to again start the process either through an arbitration or otherwise through an appeal. And I think that somewhere down the line, if we want to make this a more effective process, we need to stop it at a certain stage, or otherwise, if we're unable to stop it because of natural justice issues, then we need to limit the number of forums in which this could possibly be opened. So yes, personally, I think the multi-tiered system, it's really doubtful as to what kind of help it's giving us now.
If I may provide a war story there, I won't comment any further because I bow to that experience on the desirability of prior stages at all in multi-tier. In terms of pathology, you need to be careful. We have a case at the moment where a colleague is an arbitrator under a new expedited procedure. And the question arises on these clauses whether you're creating problems of jurisdiction or admissibility in your multi-tier procedure, which you should definitely not do. At worst, you might find that your agreement to arbitration is actually subject to some step which may be difficult to perform. A less severe but nonetheless time-wasting form is if you make your access to arbitration admissible only upon performance of a prior step, which can be abused. If I may be allowed a very short, quite amusing war story on clauses more generally, I seriously had a case before a major international institution which, on an arbitration agreement which stipulated arbitration in New York. And the institution seriously said we should spend our 3 days in upstate Albany, not New York. If you take that to its extreme by agreeing something like Paris, you might find yourself in Texas. So it might be helpful to be specific about your geography.
We've heard a lot about pathological clauses this morning, and my question goes to the Indian legal practitioners there. How do Indian courts deal with pathological clauses really? I mean, do they try as far as possible to interpret the parties' agreement to arbitrate and try to send the parties to arbitration, or are they more in the other sense? I ask this because I practice in a jurisdiction where it's sufficient to say arbitration, the clause to say arbitration, for the parties to ultimately be sent to arbitration. And that's why I'd just like to know, what is the Indian court's position if one can be generally deciphered on these sort of clauses?
So if you're looking for just a general description, the answer is yes. I mean, if an Indian court sees that the parties have intended to arbitrate, then issues such as seat, venue, other issues such as whether you need an expert determination before going to arbitration, all of that sort of falls in the wayside, and Indian courts do try and encourage parties to go in for arbitration. And I mean, Janak Bhai just mentioned a judgment, Pricol. Pricol was a case where there was no institution which was specified. There was an inexistent institution which was specified. And the Supreme Court said, well, there can't be an inexistent institution. It must be the SIAC. So again, I mean, all that is just the push that you do get from an Indian court trying to push parties to arbitration, if they broadly see that parties wanted to arbitrate their disputes and not go to court.
So I think the courts do apply principles of interpretation to find out what the real intention was and fill in the gaps or delete some unintended language. So Pricol, Enacon, all these judgments would be really in support of that proposition.
To answer your question, besides Enacon, at least I can, in my note, I have at least 4 other Supreme Court decisions, all of which have been rendered in the recent past, where repeatedly the Supreme Court has said if there is a manifest intention to arbitrate, they will save the pathological clause.
Thank you. I had a question about the use of mediation alongside arbitration. Given the potential difficulties with multi-tiered or sort of escalation clauses and the ways they could be used to disrupt arbitration, what does the panel think about other ways to encourage the use of mediation alongside arbitration, whether through cost rules or otherwise? Thank you.
Richard, do you want to take?
It's difficult. It's difficult to see the unless there's a multi-tiered sort of format in the agreement, and mediation is a prior step. It's difficult for me to see how as a practical matter, an arbitral tribunal that's been appointed in accordance with the arbitration agreement can direct or even really encourage the parties to pursue a mediation or any other alternative form of resolution of the dispute. I mean, you suggested cost, sort of through a cost mechanism. That might be a very indirect way to do it, but it seems to me that having the arbitral tribunal or the arbitrator directly involved in directing a mediation in the context of a pending arbitration is quite problematic, and probably, in my mind, creates more problems than it would solve, again, as a practical matter.
My own experience is that the best way to encourage mediation is to institutionalize it within corporations. I'd be interested to hear your view of that. Even if you've begun a mediation, and I've had personal experiences, very, very bad experiences, of being cut adrift by my client during the mediation. A mediation will only work if it personally engages the decision maker. And the only way to ensure that happens is to have a policy within the corporations. And I would start by encouraging Indian corporations to do that.
So one last question which I want to ask. In a contract where US law applies and the venue is specifically specified in Hong Kong and LCIA rules applies basically for an arbitration. So in case if the award is being granted by the arbitration tribunal, then where it will be challenged? Because the clause does not mention anything about the seat of an arbitration.
As I mentioned earlier, it will be a matter which will have to be gathered from the contract, its interpretation, as also sometimes the closest connection test. In Enocon, the Supreme Court even applied the closest connection test to decide whether or not the seat would be India or the seat would not be India. So it is a matter of interpretation, whether the intention was to call it venue or really to call it seat. If the seat is outside India, the challenge would not be in India. If the seat is India, the challenge would be in India.
So we are being timed out. So thank you so much, panel, for the thoughts and sharing of wisdom. Really appreciate it. A big round of applause for the panel.